A major test of presidential power as the Supreme Court is set to consider just how much authority President Trump has over independent federal agencies.
Right now, justices are hearing arguments in the closely watched case of a former Trump-appointed member of the Federal Trade Commission who was fired by President Trump after he said she didn't align with his agenda. I want to bring in CNN senior legal analyst Elie Honig right now. He's been listening closely to all these arguments. What have you heard so far, Elie?
Well, Wolf, it's going very well for the Trump administration so far. So the arguments are still ongoing, but the battle lines here have been drawn very clearly. The court's 6 conservative justices clearly seem to agree with the Trump administration's position that the president is the head of the executive branch and therefore can fire agency heads for any reason he wants. However, the 3 liberal justices strongly oppose that. They've been essentially arguing through their questions that Congress passed a law saying the president can only fire those agency heads for good cause.
All right, so we need to talk about something absolutely wild that's happening with Trump's legal strategy right now. And it's one of those situations where his lawyers are saying one thing in court and Trump is saying something completely different in public. And the contradiction is so glaring that it's creating this massive problem for his entire defense. Here's what's happening. Trump's legal team is in various courts arguing that he has absolute presidential immunity, that he can't be prosecuted for anything he did while in office, that the presidency puts you above the law. And when judges push back and ask tough questions, Trump's lawyers are basically admitting that, yeah, if Trump didn't have immunity, some of the things he allegedly did would absolutely be crimes. Like, they're conceding that point. They're saying the acts would be criminal for an ordinary person, but Trump gets a pass because he was president. Meanwhile, Trump himself is out there attacking judges, calling them corrupt, demanding that Congress weaken the court's power to hold him in contempt, and basically waging an all-out war on the judicial branch. So, on one hand, his lawyers are in court asking judges for mercy and special treatment. On the other hand, Trump is publicly trashing those same judges and trying to undermine their authority. And somehow, this is supposed to work as a coherent legal and political strategy.
The president should have the power to choose to remove those agency heads from the FTC and other similar agencies, really for any reason he wants.
What will a decision, Elie, in this case say about the scope of the executive power?
Yeah, well, so there is a fundamental recalibration of executive power happening in this country right now. So the argument that the Trump administration's lawyer, the Solicitor General John Sauer, is making is essentially something that's been called for a long time the unitary executive theory, meaning the president is the duly elected head of the executive branch and he can do whatever he pleases within the executive branch, and it violates separation of powers for Congress to try to come in.
So let's start with what happened in the Supreme Court immunity arguments, because this is where Trump's lawyers made the concession that's causing so much attention. The Supreme Court has been hearing arguments about whether Trump has immunity from criminal prosecution for acts he took while president. This is connected to the January 6th case and other criminal charges, but it's really about a much broader principle. Can former presidents be prosecuted at all for things they did in office? Trump's position is yes, they have absolute immunity for official acts. The prosecution's position is no, presidents are not above the law. And during oral arguments, the justices were pressing Trump's lawyer, John Sauer, on the implications of his immunity theory. And one of the justices asked, essentially, are you saying that the acts Trump is accused of would be legal, or are you saying they would be illegal, but he just can't be prosecuted for them? And Sauer's response was incredibly revealing. He acknowledged that if the court denies broad immunity, some of Trump's alleged conduct would be crimes for any ordinary person. Let me repeat that Trump's own lawyer admitted in front of the Supreme Court that the things Trump is accused of doing would be crimes if a regular person did them. The only defense is that Trump was president, so he gets special protection. Now think about what that admission means. Trump has spent years claiming that he did nothing wrong, that January 6th was a peaceful protest, that the election challenges were legitimate, that everything he did was perfect and legal. But his lawyer is standing in front of the Supreme Court saying, actually, if we don't have immunity, these acts are crimes. That completely undercuts the I did nothing wrong narrative. It's essentially an admission that Trump's behavior was criminal. But he's arguing he should get away with it because of his job title. That's not a defense based on innocence. That's a defense based on a technicality. And legal analysts immediately picked up on this because it's such a damaging concession, even if it makes sense as a legal strategy. At the same time, this is happening in court. Trump is publicly going to war with the judiciary. He's calling judges corrupt. He's calling them radical. He's saying they're out of control. He's encouraging his allies in Congress to talk about impeaching judges who rule against him and slashing the federal judiciary's budget by billions of dollars. There are proposals from Trump-aligned Republicans that would weaken judges' contempt powers, making it harder for courts to enforce their own orders when the executive branch ignores them. Trump is essentially saying, if judges won't rule in my favor, I'm going to undermine their power and make them irrelevant. The bigger picture here is that we're watching a fundamental clash between the executive and judicial branches play out in real time. Trump believes that the presidency should be essentially unchecked by the courts, that once you're elected president, you can do whatever you want and judges can't stop you or punish you. That's an incredibly dangerous view of executive power, and it matters enormously for the future of American democracy, because if Trump succeeds in establishing that presidents are above the law and that courts can't effectively check executive power, that precedent will be there for every future president. All right, so let's really dig into what Trump's lawyers actually argued and why their immunity theory is so extreme. The case in front of the Supreme Court involves Trump's federal criminal charges related to January 6th and his attempts to overturn the 2020 election. But the immunity question is broader. It's about whether former presidents can ever be criminally prosecuted for actions they took while in office. Trump's legal team argues no. Presidents have absolute immunity for official acts, and they define official acts very broadly to include basically anything a president does as part of their duties. Under this theory, presidents could order illegal actions, abuse their power, even potentially commit violent crimes. And as long as those acts were done in an official capacity, they couldn't be prosecuted. Not during their presidency and not after they leave office. The only remedy would be impeachment by Congress, and if Congress doesn't remove you, you're home free. The prosecution and many legal scholars argue this is absurd and dangerous. They point out that the Constitution doesn't grant presidents immunity from prosecution. They point out that the founders were specifically concerned about unchecked executive power and designed the system with checks and balances to prevent it. They argue that if presidents really had this immunity, it would create a massive incentive to commit crimes while in office, knowing they can't be punished. And they say impeachment is not an adequate substitute because it's a political process that's been shown ineffective when the president's party controls Congress. But Trump's team is sticking with absolute immunity because it's their best shot at avoiding prosecution. If they can get the Supreme Court to rule that former presidents can't be prosecuted, all of Trump's criminal cases go away. It would be a get-out-of-jail-free card. And this is where the concession becomes so significant. When justices asked Trump's lawyer, John Sauer, whether he was claiming the acts themselves were lawful, Sauer couldn't really say yes, because some of the acts Trump is accused of, pressuring state officials to find votes, organizing fake elector schemes, inciting a mob to stop the certification, these are pretty clearly not lawful for anyone to do. So Sauer's fallback was, okay, the acts might be criminal for an ordinary person, but presidents have immunity, so Trump can't be prosecuted. And that concession is devastating from a PR standpoint because it sounds like an admission that Trump did commit crimes. Trump's whole narrative has been that the prosecutions are witch hunts, that he did nothing wrong, but his lawyer is essentially saying, look, we're not arguing he didn't do anything wrong. We're arguing you can't punish him for it because he was president. That's a very different defense. This immunity argument is not supported by historical practice or by most legal experts. We've never really tested whether former presidents can be criminally prosecuted because we've never tried until now. Gerald Ford pardoned Richard Nixon, which suggests presidents can be prosecuted. Otherwise, why would a pardon be necessary? But we don't have definitive Supreme Court precedent. So Trump's team is asking the court to create a new expansive immunity doctrine that has never existed before. And they're doing it in a case where the underlying conduct is egregious attempts to overturn a democratic election. So if the Supreme Court sides with Trump, they're establishing a principle that will protect far worse conduct in the future. Because once you say presidents can't be prosecuted for trying to overturn elections, what can they be prosecuted for? The answer becomes nothing as long as it's done in an official capacity. Now let's talk about Trump's attacks on judges. While his lawyers are in court asking judges for favorable rulings, Trump is publicly trashing the judiciary and calling for it to be weakened. He's attacked judges overseeing his criminal cases by name, calling them corrupt and biased. He's attacked judges who've ruled against him in civil cases. He's even attacked Supreme Court justices. And these aren't just offhand comments. These are sustained, deliberate attacks designed to undermine public confidence in the judiciary and to intimidate judges into ruling in Trump's favor. Because if judges know that ruling against Trump means they'll be publicly attacked, face calls for impeachment, potentially see their budgets cut, that creates pressure to rule in Trump's favor, even if the law doesn't support it. That's not how judicial independence is supposed to work. Judges are supposed to be insulated from political pressure so they can make decisions based on law and evidence. Trump's allies in Congress have been pushing proposals that would weaken judges' ability to enforce their orders against the executive branch, specifically limiting contempt powers, making it harder for judges to hold executive branch officials in contempt when they defy court orders. We've already seen Trump administration officials ignore subpoenas and defy court orders with minimal consequences. If Congress passes legislation weakening contempt powers, judges become toothless. They can issue orders, but if the executive branch ignores them and there's no enforcement mechanism, what's the point? Courts become advisory bodies with no actual power. And that's exactly what Trump wants, a system where courts can suggest things but can't force them to comply. There's also been discussion about slashing the federal judiciary's budget. If you cut funding to courts, you slow down cases, make it harder for judges to do their jobs, and gum up the judicial system. And conveniently, the cases most affected would be cases against Trump. If courts don't have resources to move cases forward efficiently, Trump's trials get delayed. Everything grinds to a halt, and delay benefits Trump. Because the longer cases take, the more likely he maintains power and potentially gets reelected, at which point he can make federal cases go away by ordering the Justice Department to drop them. So attacking judiciary funding is strategic. It protects Trump by making the justice system dysfunctional. The broader pattern is that Trump treats the rule of law as an obstacle to overcome rather than a principle to respect. When laws and court rulings benefit him, he's all for them. When they don't, he attacks them as corrupt or rigged. And he's been remarkably effective at getting his base to go along. He's convinced millions that any judge who rules against him must be biased. Any prosecutor who charges him must be engaged in a witch hunt. And once you've convinced people that the legal system itself is corrupt and rigged, you can justify any action to defy or undermine it. That's how democracies die, through gradual erosion of institutional legitimacy until people no longer believe in or respect the rule of law. Trump's appeal of his New York hush money conviction is another example. He was convicted by a jury on 34 counts of falsifying business records. The evidence was substantial testimony, documents, financial records showing a scheme to cover up hush money payments. Trump's response has been to claim the trial was rigged, the judge was corrupt, the jury was biased. His lawyers are appealing, arguing the trial had fatal flaws. But legal experts who've reviewed the record say the prosecution's case was strong and the jury's verdict is likely to be upheld. So Trump is stuck with a criminal conviction, and his strategy is to attack its legitimacy, make supporters believe it was political persecution, and delay punishment as long as possible. So what does all of this mean for American democracy and for the rule of law going forward? Trump's immunity argument, if accepted by the Supreme Court, would create permanent protection for presidential criminality. It would establish that the most powerful person in the country is also the most protected from legal consequences. And that's backwards. In a democracy, everyone is supposed to be equal under the law. The president shouldn't get special protections that ordinary citizens don't have. If anything, we should hold presidents to a higher standard because they have more power and more ability to cause harm. But Trump's argument flips that. Presidents should be held to a lower standard or no standard at all because their job is so important that we can't risk prosecuting them even when they commit crimes. I understand the concern that prosecutions of former presidents could be weaponized for political purposes. You don't want every new administration going after the old president to settle political scores. That would be terrible for democracy, too. But the solution is not blanket immunity. The solution is prosecutorial discretion, requiring evidence of actual crimes, having cases reviewed by grand juries and decided by trial juries. All those safeguards exist to prevent politically motivated prosecutions. What we don't need is a rule that says even if a president clearly committed crimes, even if there's overwhelming evidence, even if a jury convicts them, they still can't be punished because they used to be president. That's not protecting democracy. That's creating a monarchy. Trump's attacks on judges are equally dangerous. Judicial independence is a foundational principle of American government. The whole point of lifetime tenure for federal judges is so they can make decisions without worrying about political pressure or retaliation. If judges know that ruling against a president will result in public attacks, threats of impeachment, or budget cuts, they're going to be less willing to stand up to presidential overreach. And over time, that chills judicial independence. You end up with courts that defer to the executive branch even when they shouldn't. You end up with judges afraid to enforce the law against powerful politicians. And once that happens, the separation of powers collapses because the whole system depends on each branch being willing to check the other branches. If courts are too scared to check presidential power, then there's no effective check. The president becomes effectively a dictator, limited only by their conscience and by elections. And this is where the 2026 midterms become so important. Because if courts can't or won't hold Trump accountable, if presidential immunity prevents prosecution, if judicial weakness prevents enforcement of court orders, then voters become the only real accountability mechanism. Every election becomes a referendum on whether we want to continue allowing a president who's above the law. And that puts enormous pressure on elections and makes them even more high stakes and divisive, because you're not just voting on policy anymore. You're voting on whether you want to live in a country where the president can break laws without consequence. That's a much more fundamental question, and it's the kind that tears societies apart because there's no middle ground. Either the president is above the law or they're not. The contrast with traditional conservative legal philosophy is also striking. Conservatives used to emphasize the rule of law, wanted strong courts, talked about following the Constitution and limiting government power, but Trump has completely flipped that. Now, conservatives argue for expansive executive power, for weakening judicial checks, for immunity doctrines that put presidents above the law, and moderate conservatives are uncomfortable with this shift, but they've mostly gone along because they support Trump politically or fear being primer. So you've had this complete realignment where the rule of law has become a partisan issue instead of a shared principle. And that's unhealthy for democracy, because the rule of law only works if both sides agree it matters. The international implications are worth considering too. America's standing in the world has always been partly based on our claim to be a nation of laws, not of men. We criticize authoritarian countries for having presidents above the law. We sanction dictators who imprison political opponents and ignore court rulings. But if America establishes that our president has absolute immunity and can't be held accountable by courts, what credibility do we have to criticize other countries? It's hypocrisy, and it undermines America's moral authority. Other countries will say, see, America doesn't really believe in rule of law either. They just use it as a weapon against enemies, and that makes it harder for America to promote democracy globally. Trump's lawyer's admission that his acts would be crimes for an ordinary person is going to haunt him politically, even if it helps him legally, because voters can understand that distinction. They can understand the difference between I didn't do anything wrong and I did something wrong, but I can't be punished for it. And most people, even Trump supporters, probably feel uncomfortable with the idea that the president should be able to break laws without consequences. There's a reason Trump has always insisted he did nothing wrong rather than admitting wrongdoing and claiming immunity, because the I did nothing wrong story is much more politically viable. But his lawyers have undercut that story by effectively admitting that, yeah, without immunity, these would be crimes. And Trump can't walk that back. It's in the Supreme Court record. So now Trump is stuck trying to maintain two contradictory narratives. I'm innocent, and also I need immunity because otherwise I'd be guilty.